Tonight on Nation to Nation, British Columbia adopts the principles of the UN's Declaration on the Rights of Indigenous Peoples. It could transform the way business is done.
You know, for the province to implement this bill across all ministries, it will definitely change, I think, the approach from resource industry.
Indigenous child welfare reform is set to be enacted on January 1st, but many service providers and stakeholders still don't know anything about it.
It is a real problem. I certainly would have liked to see more planning and coordination in preparation for the implementation of this law.
I'm Todd Lamourant, and welcome to Nation. British Columbia is #1 today as a bill to adopt the principles of UNDRIP became law, succeeding where the federal government failed when NDP MP Romeo Saganash's private member's bill died in the Senate last June. Chief Don Tom is Vice President of the Union of BC Indian Chiefs. He's in Victoria and joins us now to talk about BC's passing of UNDRIP. Chief Tom, welcome to Nation.
Thank you.
How big a day is this for First Nations in British Columbia?
We are excited here in British Columbia. This is BC's the first jurisdiction to implement the United Nations Declaration on the Rights of Indigenous People. We are thrilled. It's been a lot of hard work that has gone into this, and we're excited.
Do First Nations in BC care if there's now a federally sponsored UNDRIP bill? Is there still a need for one, you think, at the federal level?
Yes, there is. There is a need for one at the federal level. There definitely would improve the lives of First Nations across Canada. And if we look at the UNDRIP, it's you know, these are human rights, and these are basic rights that every Indigenous community should have, of clean drinking water, education. So there would be definitely a lot of benefit to having the federal government take this up as well.
I suppose starting tomorrow, how will this bill, this new law, change the lives of First Nations people in British Columbia?
I think as we look at proponents, or we look at government and industry who wish to do business with First Nations, there will be a path laid out, and there will be a way forward in terms of how industry and proponents and government want to do business, and so there will be a path laid forward. And it starts here in BC. There's a tremendous amount of work that has gone into this, and so for myself, it just lays the groundwork for how First Nations government and industry, people who want to do business with First Nations, can work together.
Between all this legislation and all the court victories that Indigenous people have enjoyed over the past few years, is there still a need for First Nations to be involved in the BC treaty process? Each First Nation has their own right to self-determination, and each First Nation chooses their path forward to obtaining Aboriginal rights and title, whether that's through the treaty process or not. So every individual First Nation has the right to choose which path they would like to go down. And finally, Chief Tom, why do you think that this piece of legislation, when Romeo Saganash's private member's bill failed to make it through the Senate?
Well, here in BC, we're ecstatic that we do have the NDP government, who also has a confidence and supply agreement with the BC Greens, and it's through their collaboration and through the calls to action that we were able to pass this bill. And it's through the work of the BC NDP and the BC Greens here who took on this task, and through the work with the BC First Nations Leadership Council. For us, it's the process has benefited having First Nations being directly involved in the drafting of the legislation. And I think it's a good model for whether it be Canada or other provinces who wish to take on implementing the United Nations declarations on the rights of Indigenous people.
I know that this bill is talking about just human rights, but do you think it does anything when you're perhaps in conflict with other levels of government over resource development?
This sets a path forward. Again, this would clearly show what government and industry needs to do to one, to work with First Nations, and looking at the Chilcotin and free prior informed consent, and for the province to implement this bill across all ministries. It will definitely change, I think, the approach from resource industry. And I think it also will change, whether it be proponents or government who just want to go roughshod over Aboriginal rights and title. And so through this bill, it would set the foundation as to how do we have these conversations and how do we work with First Nations, and it's shared decision making. And it's something that all Canadians and British Columbians have the opportunity for, and through this bill, First Nations in BC have that opportunity to have shared decision making as well.
Chief Tom, congratulations, and go out and enjoy this day. Thank you for speaking to me.
Thank you.
Scott Fraser is the province's Minister of Indigenous Relations and Reconciliation, and I spoke to him prior to this morning's ceremony as the bill received royal assent. Minister Fraser, welcome to Nation to Nation.
Great to be here, Todd.
Now, why did the BC government not wait for Ottawa to pass its own UNDRIP legislation?
Well, we had made a commitment over 2 years ago. It was part of our election commitment in 2017 to embrace UNDRIP, and the Truth and Reconciliation Commission's calls to action. And we've been working on it ever since. We were certainly hopeful that the federal government would be in step with us, but as you know, that fell off the order papers when it hit the Senate and the bid dropped. So we decided we were not going to let that hold us up. There was some fear that we might stop what we were doing because the federal government had no success. But we're not going to do that. We're going to keep going. We need to address reconciliation and the found Indigenous relationship in this province, whether or not in a new way, whether or not the federal government was with us.
Why do you think your bill passed, whereas the federal government's, or I should say the private member's bill did not?
Well, one thing is, I guess, just on reflecting on the question, Todd, we don't have a Senate at the provincial level. We had the agreement. We have a agreement with the Green Party, who have 3 members in the legislature here. So we knew we had the numbers to get this through. They were supportive also. But we were committed to doing this. Even though the Truth and Reconciliation Commission's calls to action, one of the key calls to action was that governments needed to adopt the UN Declaration on the Rights of Indigenous Peoples. And that call to action came in 2015. And here we are in 2019, and no government had taken that seriously enough to do it. So we have become the first province, the first jurisdiction in North America to do so. And I'm hoping that our federal partners will continue, since they're through the election, and fulfill their commitments here. We'd like to have that on the partnership. And we're hoping that other provinces, territories will also follow us.
Well, how different or similar is this bill to Romeo Saganash's private member's bill, C-262?
Sure. So our bill, Bill 41, it basically tracks Romeo Saganash's bill C-262. So that's the big similarity. We have added a couple of other pieces to our bill. One that will allow us to recognize different types of governance structures, Indigenous governance structures, it's an enabling piece to the bill, so that we can get beyond the definition under the Indian Act of a ban. So this will help us, I think, it's a tool that will help us accomplish implementing the UN Declaration. We also have another addition to it. It's about allowing us to enter into shared decision-making agreements with governance, with governing bodies, Indigenous governing bodies. So it's a more advanced, I believe, a more advanced bill than what the federal government did. C-262 was funded.
Why did your government not have similar concerns as the federal Conservative Party that an UNDRIP bill will give a veto to First Nations when it comes to resource development?
Yeah, and I with all due respect, I think they're the only party in Canada that takes that position. The fact is there is no veto in the UN Declaration on the Rights of Indigenous Peoples. There's 46 articles. The word veto is not used. And as in our bill, Bill 41, a piece of legislation we just passed third reading yesterday. Our bill does not contemplate veto either.
Finally, Minister Fraser, what advice would you give the federal government about getting an UNDRIP bill passed?
I would suggest to Prime Minister Trudeau that they introduce a government bill as opposed to a private member's bill, and a government bill that reflects Romeo Saganash's great work. I think in the parliamentary system federally, having a government bill, it's much more likely to get through Parliament and through the whole system successfully. I think that's what needs to happen. And if they, I certainly will be talking to my federal counterparts. They've just been, as you know, the cabinet's been appointed. So I will be talking to Mr. Bennett in the very near future. I will be urging her to let's get on with this. It's time for the country, not just the province of British Columbia, to make history.
Okay, Minister Fraser, I want to thank you for taking some time out of your day to speak to us. Thank you.
It's my pleasure, Todd. You take care.
After the break, a child protection lawyer has concerns about the upcoming implementation of Indigenous child welfare reform. Welcome back. Bill C-92 is legislation passed last June. It will reform Indigenous child welfare, and it comes into effect on January 1st. But questions are coming out about what is the transition plan. The short answer is that there doesn't appear to be one yet. Manitoba's Minister for Child and Family Services, Heather Stephenson, slammed this lack of detail last week. And child protection lawyers are also being left in the dark. To talk more about this, I'm now joined by Judith Ray. She's a Toronto lawyer who specializes in Indigenous governance, health, education, and child welfare. Welcome to Nation, Ms. Ray.
Thanks, Todd.
Now, first off, how much of a game changer is C-92? What can it bring to the table?
Well, C-92 does two things. One is that it brings in a set of about 10 federal rules that add on to existing child welfare laws. That makes change. It will have an impact. We will start to see those impacts across the country January 1st. I wouldn't say it's a game changer, but C-92 also does a second thing, which is that it sets out a pathway for the exercise of Indigenous government's own jurisdiction in child and family services. That is a game changer, and that will take more time to really take effect.
Now, your colleagues in the legal profession are coming across a lot of people who deal with child welfare services, and they've never heard of the legislation. How can it be rolled out when there's this level of ignorance out there still?
It is a real problem. I certainly would have liked to see more planning and coordination in preparation for the implementation of this law. You know, when we see the new federal rules take effect, for example, January 1st, it would be good if child welfare agencies, child welfare lawyers across the country, courts, judges were more aware, more informed, better trained about those additional 10 rules that are going to start taking effect. And likewise, if provincial governments and the sector as a whole were, not to mention First Nations and Indigenous governments, better prepared for the options, opportunities, and what people might expect around the exercise of jurisdiction, which is more of a process that takes time. There is still, it's still possible within the sector for people to continue getting informed and prepare themselves. But because of the timing of how this legislation rolled out, we haven't seen as much of that coordination and preparation as I would have liked. And there's a cross-jurisdictional dimension to it, of course. The federal government has passed the legislation, but a lot of what takes effect under it happens a little bit differently within each province and territory.
Well, when you talk about that, there doesn't seem to have been any discussions, if you go by what Ms. Stephenson, the Manitoba Minister of Child and Family Services, said just this last Friday. I mean, just how concerned, I guess, should provincial officials be?
Well, I think it's on provincial officials to get themselves prepared as well. I don't think there's been a lot that's happened because the federal government announced that it would come into effect January 1st. They made that announcement on the eve of the federal election. I didn't see anything taking place federally either in the last couple of months and during the election period. So it is an issue, and I don't dispute what she's saying, and there is a real issue out there. On the other hand, it was passed in June. That was 6 odd months ago. There is still an opportunity, and there has been, for provinces, courts, lawyers, agencies to get informed about the legislation. And it is their duty to get informed about any changes in the law that take place. This is a change in the law taking place. And I encourage those out there in the sector to look it up. If you haven't heard of the new federal child welfare law, which was formerly Bill C-92, it is urgent for you to inform yourself if you're part of this sector and start to be informed about what's taking place.
Should it have been this January 1st deadline been set when there is no significant funding or resources being set aside?
Well, the funding and resources has been a question from the beginning, and no matter what date it comes into effect, that would be an issue and is going to be an issue. It really is an issue, not so much for as I said, there's kind of 10 federal rules that come into effect. The funding is not so much an issue there. Those are just additional rules that are going to start applying in addition to the kind of baseline of provincial and territorial child welfare laws in effect. Where the funding piece is more significant is in the second part of the law, which is where First Nations and other Indigenous governments have the opportunity to use the law, if they wish to do so, to assist in the exercise of their jurisdiction. And if they do that, there are resource needs implicated in that, both in terms of First Nation and other Indigenous governments developing laws, looking at best practices, getting technical support, consulting within their communities, and then negotiating coordination agreements with their province, territory, and the federal government, and then, of course, implementing their laws and child welfare systems. And that, of course, will depend on what they choose to legislate. There will be resource needs there. The message I think we're hearing from the federal government is we'll take that step by step as it comes, but certainly there will be a resource need there, and the lack of certainty around that creates, uncertainty a bit in terms of that process.
You kind of talked a bit about it, but how ready are First Nations and their authorities to assume full legal responsibility for what will be a very sensitive area?
Well, I think First Nations and other Indigenous governments, I work most closely with First Nations, are actually very well placed to self-govern in the area of child and family services. First Nations communities have been heavily impacted by very dysfunctional child welfare systems. They have seen firsthand children go into that system, children come out. Many leaders themselves and lead staff have been personally impacted within themselves, within their families, within extended families. Absolutely. I feel like every First Nations person within their extended family has experienced the system. There's actually a very deep knowledge of the system and a lot of deep knowledge about children and families, what works well for children and families.
Ultimately, I know here N2N producer Kenneth Jackson has written a lot about, especially about the deaths of kids in care. Do you foresee that this won't happen anymore once First Nations do take over full jurisdiction of child welfare?
I would like to say that, but no one can guarantee that. This is a tough area. Child and family services and families that are struggling is a very complex area, and no one has I mean, no one has a miracle cure, right, for the depth of trauma that exists in many families and communities and within individuals. There's no magic cure there, but I think it will be an uneven road. I think the journey in different areas will be different. But overall, I do think that there is hope to be had in respecting First Nations self-determination in this area. And I do think that there's a lot of promise there in terms of First Nations and other Indigenous governments knowing their own communities, knowing their own families, and having some better ideas about what's not working and what could work better.
Well, let's certainly hope so. This is such a terrible tragedy that's been happening for decades. Ms. Ray, I want to thank you for speaking to me.
Thanks, Todd.
We'll have more after another short break. Welcome back. As far as Parliament Hill goes, it was a very busy day. And it all began when Conservative leader Andrew Scheer announced his leadership team. However, he didn't announce who would be opposition critics, saving that for a later date. As you may recall, frequent guest here on Nation to Nation, BC Conservative MP Kathy McLeod has been Indigenous Affairs critic. As reported on APTN National News, NDP leader Jagmeet Singh made a surprise announcement, naming himself critic of Indigenous services and Crown Indigenous relations.
Because it's so important to me, and because during the campaign we saw some really powerful examples of the unfairness. In Grassy Narrows, a community that's faced mercury poisoning for so many years and so many years of negligence, because this government is still taking Indigenous kids to court. They're refusing to follow through on the decision and the ruling of the Human Rights Tribunal. It's clear that they need to be pushed to do what's right.
The Premier of Nunavut was also on the Hill. After coming out of a meeting with Prime Minister Trudeau, Joe Savikita was asked about his opposition to the carbon tax.
In Nunavut, it's just a tax because we don't have any alternative energy sources. And I brought it up that climate change is affecting the Arctic and Nunavut more than anywhere else, like it's warming at 3 times the rate. But we don't have any alternative energy source right now as we speak, as wind's not reliable and solar's not that reliable, and when you get in the higher Arctic where you got 24-hour dark for 4 months, it's absolutely not reliable.
And the Senate held a press conference. It was to talk about stopping procedures that delay the speedy debate and passage of government legislation. But Senator Lynn Bayek came up. She was suspended for racist letters toward Indigenous people she had posted on her website. Yesterday, she issued a statement. It says she's met all 5 requirements imposed by an ethics committee. Senator Yuan Wu was asked about it.
I have no comment on her letter except to say that we have established a process whereby the Committee on Conflict of Interest and Ethics will reconvene. They will deliberate and prepare a compliance report on whether Senator Bayek has in fact met those 5 tests. And until that report comes out, there's really nothing more to be said.
That's all we have for tonight. Next week, we'll be broadcasting from the Assembly of First Nations annual general meeting here in Ottawa. Until then, I'm Todd Lamoran, and thanks for watching.